All right, so this right here is from a bankruptcy case, everybody. Before I get going, I just want to say this video is for educational purposes only, everybody, and it's also for entertainment purposes only. And this video is for all my folks out there who ever thought about filing bankruptcy. This is explanation of bankruptcy discharge in a chapter 13 case right here. Finna drop a gem on y'all head, so like I said, if this pertains to you, you might want to listen up. And this comes from a bankruptcy case. All right, so let's check this out, y'all. It says this court order grants a discharge to the person named as the debtor after the debtor has completed all payments under the Chapter 13 plan. It is not a dismissal of the case, y'all. So this is a court order granting a discharge to the person named as the debtor after the debtor has completed all the payments under the Chapter 13 plan. Collection of discharge debts prohibited, y'all. The discharge prohibits any attempt to collect from the debtor a debt that has been discharged. For example, a creditor is not permitted to contact a debtor by mail, phone, or otherwise to file or continue a lawsuit, to attach wages or other property, or to take any other action to collect a discharged debt from the debtor. In a case involving community property, there are also special rules that protect certain community property owned by the debtor's spouse. Even if that spouse did not file a bankruptcy case, a creditor who violates this order can be required to pay damages and attorney fees to the debtor. Now, this is what I felt like was the most important part. However, a creditor may have the right to enforce a valid lien, such as a mortgage or security interest, against the debtor's property after the bankruptcy if that lien was not avoided or eliminated in the bankruptcy case, y'all. So let's pay close attention to that part. This is for y'all now, who it pertains to. However, a creditor may have the right to enforce a valid lien, such as the mortgage if it's still money left over, or if the creditor has any ties in the security interest against the debtor's property after the bankruptcy. If it was not avoided or eliminated in the bankruptcy case as a whole, they can still lien your property, y'all. So you can file the bankruptcy, but if that mortgage, the terms of the mortgage, or the security interest wasn't eliminated as well with the discharge, that means they can come and take your property still, or whatever they have a security interest in. So when y'all handling these bankruptcies, just make sure that the creditor has no mortgage payments that he can, bring up and try to hold against you, or no ties in the security interest. You see what I'm saying? Because they can still file a lien, even though you discharge the debt, you file bankruptcy. If that was not consulted or eliminated in the bankruptcy case, they can still, Also, a debtor may voluntarily pay any debt that has been discharged. So if you discharge your debt, basically, you file bankruptcy and they come right back at you saying that, hey, you owe these payments, and you voluntarily pay it, that means you signed right back up to pay some shit that was already discharged, y'all.